Matter of PC versus Stony Brook.
May it please the court, Elizabeth Brody for Stony Brook University. I'd like to reserve 3 minutes for rebuttal.
Yes.
In this substantial evidence case, the Second Department committed error by drawing its own inferences, reweighing the evidence, and substituting its judgment for that of the university. The proper inquiry here is whether any reasonable fact finder could have reached the determination that the respondent was responsible for sexual misconduct.
Can you give an example where in the majority opinion one would read it as reweighing the evidence?
Certainly. So for the example of choking, so in the hearing, the complainant consistently stated that she, quote, snapped back into it at some point because of how hard the respondent was choking her. She remembered trying to pry his hands off of her neck, but he was stronger than she was and didn't budge. The respondent cross-examined her on this issue at the hearing, and she confirmed her earlier testimony. And there was no evidence at the hearing that respondent either didn't choke the complainant or obtained her consent to do so. The Second Department did not discuss this evidence at all. Instead, it completely dismissed it based on a theory that had not been raised by the respondent either to the university or even in his brief to the Second Department. They also reweighed the evidence.
What that theory was about incapacitation based on the alcohol or something else?
No, it was something
Well, that didn't
else.
fit into the 3 charges?
I believe the Second Department's theory was that within the student handbook, there was a 4th charge.
I see.
I think it's sexually violent contact during sexual intercourse. And even though, again, the respondent didn't raise this to the university, didn't raise it in its briefs, the Second Department sua sponte said, well, it seems like choking really falls under that theory. That wasn't charged. Therefore, we're not going to discuss the choking evidence at all.
Well, so that's not really a reweighing.
But it is
right?
an
It's-
impermissible disregarding.
Okay,
It is also giving that evidence 0 weight. But I can give
Well,
another example.
but it sounds like it's not on a weight of the evidence instead of sufficiency sort of thing and not substantial deference. It sounds like it's a legal error is what you're saying there. See if you can give an example that fits Judge Rivera's question.
Certainly. So the complainant testified at the hearing that she had fallen asleep during intercourse with the respondent and that, quote, I woke up and it was still happening. He didn't stop. The respondent himself admitted that the complainant had lost consciousness, thus confirming it wasn't a mere feeling that she had lost consciousness. He initially said, no, you didn't, when she asked, and then he said, you were only out for a second. So that, again, but what the Second Department found when it itself reweighed the evidence was that she had merely felt like she had lost consciousness. But there was other evidence in the record as well.
It seemed to me that in the initial notice that he was given, that it relied on incapacitation as the theory for why he was liable for these violations. But then the determination seems to me not to rest on incapacitation. There's not a finding. What do we make of that?
So I want to be very clear on this, Judge Halligan. Any argument about the notice of charges is not properly preserved because it was not presented to the university.
I understand you, but setting aside the preservation point, is there not some shift in terms of the basis for liability? How would he have known what to defend himself against if the theory is failure to show affirmative consent as opposed to incapacitation?
So there are 2 reasons for that go to your Honor's question. The first is that the notice charged the respondent with violating 3 provisions of the student code, each of which had as an element, respectively, that the conduct was unwelcome, that it was without consent, and that it was unwanted. The word non-consensual is also in the name of 2 of the charges.
But
And
it
thus he was
seems
on
like,
notice.
generally with any sort of proceeding, you have, a theory of the case, if you will, right? And it seemed to me that the initial theory was incapacitation, and then it changed gears and was more the failure to establish affirmative consent.
What the notice of charges said was that our office has received a complaint that you engaged in the following conduct when she was incapacitated by alcohol and unable to consent. Nowhere in the notice to say Does it say she otherwise consented, consent won't be at issue, we're stipulating to consent?
Is this
And I'll-
you might have just answered my question, but I was going to ask you, is this a disputed issue? Because I had the impression that both sides agreed that incapacitation due to intoxication wasn't an issue in this case, and that it was really just about whether or not consent was present. Am I incorrect? Are you disputing, or is your adversary disputing that?
I agree with you that it's,
Yeah, well, I
that
kind of
it's not
figured
an
you
issue.
would. Was it presented, I thought it was presented as a concession below, at least at the appellate division, that incapacity by intoxication was no longer an issue in this case.
Right, I want to make sure I'm understanding Your Honor's question correctly. So that's correct. The hearing board and the university made the finding regardless of whether she was incapacitated by alcohol. That was their finding. And the way that its findings were structured were as follows. For each charge, it said, for example, non-consensual sexual contact. This occurs when the conduct is unwelcome or unwanted. The next sentence, the complainant gave the following evidence in support of the fact that it was unwanted, and then it listed all the evidence. So, and then at the end, it concluded that regardless of whether or not she was incapacitated by alcohol, there was simply no affirmative consent in the first place. And just returning to Judge Halligan's question briefly, how was he supposed to know? Well, he in fact did know. He did in fact present evidence about affirmative consent, as we discussed in the brief. Part of his prepared statement, which he had prepared with counsel before the hearing, was devoted to the issue of what parts of her statement constituted affirmative consent. That's at page 163 to 164 of the record. And among the few types of questions that he chose to answer at the hearing were those about affirmative consent. And
The student code of conduct appears to me to have a presumption of not responsible, right? What does that mean as a practical matter?
So I believe this also came up during oral argument in matter of Haug. And so what that means is that if the complainant had gotten up there and said, I don't have a single memory of the night, I don't know what happened, but I know intercourse occurred, then he would be not responsible because there would be no evidence in the record that there was no affirmative consent.
So when
And
you look at the
does-
board, I'm sorry, go ahead.
I was, just to follow up if I can, so does that mean that there is no requirement for the student to present evidence? I realize there may be evidence on the other side in the record, but is that correct?
That is correct, yes.
Okay, so when I look at the findings from each of the panel members, it seems to me that, I can't remember if it's all or all but one, of them expressly note that he did not present any evidence. And I find that a little hard to square with the proposition that you don't have to defend yourself and that you have a presumption of not responsible. I mean, there is also other evidence in the record, I realize, but the fact that that appears to be an explicit ground on which the panel members are relying seems hard to square with that presumption.
So the operative findings here are not the handwritten notes from each member of the panel, but the decision.
And we
decision
can't
after
take
the hearing.
into account the handwritten notes in the record as to what the basis for their determination is?
You can consider it, but I think what the determination makes clear is that there was evidence in the record that the conduct was unwanted or unwelcome, and I would like to use some of my time to talk about
I
that.
do want to go
evidence.
back to that question because that's actually where I was going to go. So put aside the difference between the determination and the let's assume that the things that are in the actual board members' notes were in the determination. Would that be proper to rest on the silence, given the presumption of innocence?
No, but I don't think that's what each panel member did.
The
And the
instructions to the panel
determination,
member in those sections say, provide basis for decision below, reference evidence and testimony presented provided, and then I think each of them does say, well, he refused to answer these questions, and they're listing that as a reason for the decision.
but the decision itself makes clear that there was substantial evidence in the record, and evidence by preponderance of the record, that there was no consent to at least 3 of the acts. And I want to be clear.
Can I,
mean,
can I approach that question from a different angle? You started by saying that if a complainant were to testify, I don't remember what happened, and it's all a haze to me, that that presumption would probably operate to create a finding of non-responsible, right? Now, if the complainant does testify and says certain things which the review board, that's the first level, right? The review board, which the review board accepts, finds credible, does that relieve the respondent of the responsibility of rebutting that testimony?
No, if there's evidence in the record that would
Yes.
establish the charges, and it's the school's burden, but if the school meets its burden to establish the charges and puts forward that evidence, it's still, I mean, he doesn't have to testify, he doesn't have to put in his
No,
own
but I'm
evidence,
saying if a prima facie case is made out,
Yes.
this presumption wouldn't relieve the respondent of the responsibility of challenging that evidence,
No, he would
right?
still have to put forward evidence.
So could, I'm sorry, just one last question. So that notation about, he didn't offer any evidence, or could that just simply be a reflection of the fact that he did not present any evidence to rebut the evidence that the complainant put in?
That's exactly correct, and much more eloquently where I was trying to go when I was talking
Well,
about
I'm
the...
a lot older than you are.
But we don't have any way to know that, one way or the other, do we?
Well, in the written decision, again, the university said, here are the elements of the charges. It's that specific conduct, respectively, advances, sexual contact, sexual intercourse are unwanted. Here is the, and then it goes through and lists, here's the substantial evidence in the record that it's unwanted.
And my point is just,
And
it
at the
does-
end, I'm sorry.
Go ahead.
And at the end, it says, that regardless of her incapacity, regardless of whether or not she's incapacitated by alcohol, he didn't put forward any evidence to rebut that.
But isn't this somewhat, this whole argument, it seems to me confusing a bit the right against self-incrimination with the burden of proof? Because it seems like part of the problem here may be he didn't testify and almost holding that against the respondent. But in a civil proceeding, there's a burden of proof to prove somebody did something, let's say a securities fraud case. And you don't have to testify, but if you don't, or you take the fifth, then, that actually can be held against you in that civil proceeding. So it seems to me like there's a mixing of things here. Like, there's a presumption, so there's a burden on the school to come forward with proof, but there's no right against self-incrimination here. You can not answer, and you have the right to do that, but there's no, then, instruction that you can't use that against somebody. Why would that be the case? It's a civil proceeding.
That's correct, and the second department dissenting opinion made that point, and I do think it's really important. I see that my time has expired, so if I could just briefly conclude.
Yes, there was something you wanted to get to. Go ahead.
There are at least, I just want to emphasize, there are at least 3 times in the evening where the complainant unequivocally revoked any consent that she allegedly may have given. First, she physically resisted being choked by trying to pry the respondent's hands off of her neck. She was unsuccessful. She verbalized being uncomfortable once the students were already inside of her car, and she fell asleep and lost consciousness during intercourse in the car. Thank you.
May it please the court, I'm Alexander Klein with Barquette, Epstein, Huron, Aldea, and Laturco. I'm here on behalf of the respondent, PC. The appellate division's vacatur of the disciplinary penalty should be affirmed. This case was brought based upon one question alone that permeated the charges, the hearing, the thinking of the panel members afterward, and of the appeals decision, and that was the accuser too incapacitated to consent? Now, there's 2 ways that a non-consent can be found. One is if it is not offered.
Too incapacitated by reason of intoxication or something else?
Just intoxication, Your Honor. And this formed the basis of the charges that were given to my client.
Was
which
that,
said,
was that objected to at some point during the proceeding?
was what objected to, Your Honor?
That the ultimate evidence in the case didn't establish that the complainant was too intoxicated to give consent?
It was, and not only was it contested, it was the only thing that was an issue at the hearing. The whole case, the whole hearing revolved around whether there was consent. In fact, my client,
No, but that's a different question. You know, take a look at, I'm sure you've looked at it many times, but the enough is enough law, 6441. It lays out two theories of consent. The one that you started by referring to, which I think is in the second sentence, which is that depending on the degree of intoxication, someone under the influence may be incapacitated and therefore unable to give consent. But there's a whole proceeding section that talks about lack of consent in other ways.
absolutely.
So, you know, I think what your adversary is saying, and the reason why I'm holding you to account just for using the word consent, is you might not have the second kind of consent, but that doesn't foreclose the possibility that you don't have the first one.
I 100% agree, Your Honor. The question is, can a school play bait and switch with those two different types of consent? When you have the entire apparatus of the school focused on one kind of consent or non-consent, you can't then switch after the hearing is done.
I might not disagree with you about that, but is that something that was litigated through the course of the Article 78 and the appellate division and all of that?
It was litigated as soon as it could be litigated, which is to say there was no showing, no sign that this could have been the decision of the school until after the school had made this decision on new grounds. For instance, the charges were based upon the notion that the accuser was, quote, unable to give consent. And so
Well, I'm going to stop you there for a second, because I'm looking at page 214 of the record, and it's a document dated on December 30th, 2019, which is a notice of charges. And it says that the university, in the first paragraph, received a report about a female student while she was incapacitated due to alcohol, which seems to me that it indicates what the report is alleging. And then it says on the next page that you are alleged to have violated the following sections of the Code of Student Responsibility, and it lays out sexual misconduct, sexual harassment, non-consensual sexual conduct, and the rest of the charges without talking about incapacity due to alcohol. So how is it that you're not on notice?
Your Honor, I don't want to turn this into a notice question. The fact that the...
Well, where's the bait and switch, then? I'll use your words, yeah.
Okay, so the bait and switch is as follows. Starting with the charges, they lay out that it is alleged that you engaged in sexual contact with a female student while she was incapacitated due to alcohol and unable to give consent. But that doesn't end there. That's just the beginning. We then have the hearing where the accuser goes through, in her own words, the serial affirmative consents that she provided throughout the night.
But she can, at any time, withdraw consent.
So she can withdraw consent at any time. But in her own words, she overcame his protestations of no. He said it would be a bad idea. She said that my friends don't get to control my body.
So where's the consent to the choking?
A few things, Your Honor, about the choking. And the choking itself does not form a basis of the school's decision until after the decision has already been made. The appeals decision, for example, claims to affirm the school's decision based upon incapacitation again. And yet, that is not the basis that the underlying panel rendered the decision on. To the choking, she says she wouldn't have allowed the choking, quote, if she were not intoxicated.
Did she not testify at some point during the hearing that when she became aware that she was being choked, she tried to remove his hands, but he was too strong and she couldn't remove them?
She testified that, and it was in her statement.
Could that not form the basis of an implicit revocation of consent?
What she also said is that she was blackout during this entire time, and she only remembers that for a moment while she was present.
I know she was threading in and out I don't know exactly what blackout means. I think it probably means something different than passed out, right? I don't know. But she does say, but what I do remember is that he was choking me, and I tried to take his hands off my neck, but I couldn't. He was too strong.
Right, so she says that she was, quote, only present for a, quote, short amount of time.
But doesn't that go to, some of the things that you're pointing to seems to go to credibility, and isn't it that for the fact finders to determine how much weight to give to her testimony as to what she actually remembers?
What
And
I
if
wanted to
there's
focus-
nothing to contradict her version?
Sure. What I want to focus on is what the school actually decided. And if we were here, based upon a finding that she had not had the capacity to consent, or even if there had been a finding here that she had withdrawn consent because she tried to pry his hands off her neck, this would be a different case. If you look at the actual decision from the panel or from the appeals board, no one mentions the attempt to pry his hands off of her neck, and that's probably because she says that she wasn't with it long enough to determine how promptly.
so
To
you're
be
saying they
clear,
have-
as you read the university's decision, what is it that they have determined? It could be more
It's-
artfully crafted, yes, but when you read it, what are you arguing it has found?
Okay, so it depends upon what you look at.
Well, I'm asking you what you look at. It's your argument. What's your argument about what they actually decided? That's the bait and
The
switch.
the
What is
school
it?
decided that there was a lack of affirmative consent,
Okay.
not that there was consent vitiating incapacitation. That's what they held after the hearing.
Well, if she's intoxicated and that's why she blacks out and she's out, that's of course an obvious example of incapacitation.
Absolutely.
But it's also incapacitation as in you cannot consent, you are blacked out.
It is, but it's not just that the school left the issue alone. They affirmatively came forward and said,
But I'm saying, why aren't you on notice of that? Why isn't that clear notice?
because it's not a matter of notice.
Well, I thought it was. I thought that was your point about the bait and switch.
No, the
That
bait and
your-
switch.
That your client did not know how to defend themselves.
No, it's not a matter of not knowing how to defend himself. The bait and switch is a question of arbitrariness.
Okay.
The school has an obligation to live up to its own rules and to not act arbitrarily and capriciously.
So what rule are you saying they didn't adhere to?
Two rules, and they're formed into the same sentence in the code, which is that the students are entitled to a presumption of not responsible absent a finding by a preponderance of the evidence.
So how is that violated here? I mean, Judge Garcia suggested that there's a burden of proof that is at play here, and if there is evidence in the record from the victim and it's not rebutted, then it's fair to draw whatever inferences you might draw from that. How's the presumption violated?
In the appeals decision and in the panel's decision and in their deliberations, which you commented on during my friend's argument, they all talk about of three reasons for finding in favor of the school, that he could not step forward and identify the affirmative consent or chose not to answer questions.
Why isn't that okay?
Because there's a difference between this case versus a plenary civil action. And I think that there was a question earlier about, well, you could certainly use it against someone in a normal civil case if they don't take the witness stand.
Well, suppose it's a criminal case, right? And let's even say the Fifth Amendment's at play, but the defendant takes the stand.
Sure.
So you think if the defendant then has testified affirmatively a bunch of stuff and is asked a question on cross-examination and says, I'm not going to answer that the jury can't take a negative inference from that?
They can, Your Honor, perhaps, but my client didn't come up and take the witness stand and
Well, he made an
go
opening
through all that.
statement and then answered a bunch of questions, and we think established he had the right not to show up at all.
Right. But this court has held that there is not a presumption of innocence in a normal civil action. And that's what allows someone to have an adverse inference held against them. For example, if they refuse to testify in a manner that they otherwise would. The most recent case that I found that this court held that was in a case called Reed versus State.
But so are you suggesting that if there's testimony from a victim and whoever is accused of the violation declines to provide any evidence, that the panel cannot simply draw whatever inferences or conclusions it wants from the testimony that's in the record?
It absolutely can.
So how is that-
Is it your argument that that involves taking some sort of adverse inference against the non-testifying witness because they drew reasonable conclusions based on the evidence that they did have in front of them?
No. What I'm saying is that if the accused doesn't testify in the case,
Yeah.
then the question as to whether the decision should be upheld has to be based upon the evidence that is brought to bear against the accused. And in
So
this
if they
case,
note that he didn't provide any evidence to the contrary, then that's no good. If they had said everything they said, but just not noted he didn't provide any response, that would have been okay. But because they noted he didn't respond to that question, then it's not okay under your theory. Let's say the victim came in, she testified to X, Y, and Z, same facts, that's one decision. Second decision, same part, same exact lead up, but then they say, and then, the respondent didn't testify. So the second one would be bad in your view.
absolutely, Your Honor. I mean, just like if they came up with 3 reasons why they wanted to confirm the findings against him, 2 of which were the accuser's testimony, and the third was that they flipped a coin, that wouldn't be appropriate, and it would take away from the decision-making that had come in before.
So simply noting that he didn't provide evidence vitiates whatever findings they made based upon the evidence that they did have?
What did they actually find?
Well, there are 2 things. The choking, which we discussed a lot, and we could go over it. And then there's the passing out in the car,
Right.
which, and I read, I was talking to your adversary about 6441. I read the first part of 6441 saying that incapacitation may be caused by lack of consciousness or being asleep or being involuntary restrained, et cetera, et cetera. And it goes on to say, I think, but the point is, her loss of consciousness in the car, which I believe she testified, not only that she was unconscious, but that she asked him if she lost consciousness, and he confirmed it, ends consent.
Your Honor, but that is purely an incapacitation claim.
No, but that's not lack of ability to give consent due to intoxication. That's the negation of consent by loss of consciousness. That's different.
Loss of consciousness, there's no theory here that she lost consciousness for any reason other than incapacitation.
Whatever. She could be narcoleptic, maybe she got hit on the head with a brick, or maybe she was really drunk and she lost consciousness. But the rule says any loss of consciousness for, it's a list, but it's effectively any reason at all, ends consent. And I think it even says you have to stop what you're doing right there. And her testimony was, which I assume was credited by the review board, was that he didn't stop. He kept on going after she lost consciousness.
So there's no version of the facts here that the falling asleep in the car would have been related to anything other than her intoxication.
I understand that's your argument, counsel, but I'm saying, so what? Whatever the reason is for the loss of consciousness, she lost it. And that ends consent, doesn't it?
It does if that's what the school finds, which is not what they found. The school didn't find that he was liable because of her falling asleep in the car for some reason other than intoxication. One final note I would make about the choking, which is the most serious charge that was brought to bear against my client was non-consensual sexual intercourse. The choking would not bear upon that charge.
But the car.
Say that again? What would not bear on that?
Choking.
Would not bear on?
Would not bear upon the charge of non-consensual sexual intercourse.
Really?
It
I'm
wouldn't.
not sure what you mean by it doesn't bear on it.
It wouldn't. So let's say.
It wouldn't be necessary to prove it?
Let's say the court found that the only thing. Let's say the court found that the choking was done without affirmative consent.
Okay.
Okay, and that was the only finding that it was going to uphold against my client. Okay, that would not be enough to sustain a charge of intercourse without affirmative consent. It could possibly pertain to a charge of sexual harassment but it would not support a charge of intercourse because the choking was not the intercourse would not have been what was done without affirmative consent.
Does it not affect consent? If there's force or intimidation, is that still consent?
Right, but the choking...
Choking is not forceful contact?
No, it is, but it's not intercourse.
But
right?
if it allows you to do the intercourse, is that not?
That's not the allegation. The allegation is that she instigated the sex.
So is it your argument that he could hit her, slap her, do anything that he wanted because of the way they wrote the charges?
No, but let's say she affirmatively consented to sex, and then he became violent during sex in a way that was lacking in affirmative consent. That would not vitiate the affirmative consent to the sex, but it could give rise to a different violation of the
Well, no,
How
under the
is that? That's part of the sexual act.
Under the University Code of Student Responsibility, it says consent may be revoked or withdrawn at any time, and such revocation may take place through physical resistance.
Right.
So when she's saying she's prying off his hands as he's choking her, the consent is gone.
The consent to the choking, not the consent to the sexual intercourse. After this took place, keep in mind, this took place in the woods. After this takes place, they go to her car, she leads him to her car.
Where's the consent to the choking that is then revoked?
She says that she wouldn't have done it, quote unquote, if she were not intoxicated, i.e., she did consent to it, but she was intoxicated.
Done the choking?
Yes, that's with regard to the choking. She says she went along with everything he did. She says that, she admits that she continued having sex with him afterward in the woods and then back in her own car, which she led him to, which she unlocked, where she performed oral sex on him.
Sir, can she not initially she can give consent in the woods, right?
Correct.
Separate and distinct from what happened in the car.
Sure.
She can go to some other place and have consented to other things and then withdraw her consent at any time. Do you not agree?
Absolutely, I agree.
And just because she consents to one thing does not mean she necessarily consents to any and everything he may wish to do.
Correct. But it's not, just because it doesn't prove it on its own, doesn't mean that we throw the entire story out the window. What we know from the facts of this case, just from a big picture, is she instigated the sex. She made him get a condom.
There you go again, because you're treating this as if it's one episode, and because she consented to some part of it, then she must have consented to all of it. And I, for one, reject that. And I think the university rejected that. But I think ultimately we're going back to a credibility finding, which is not what we're going to engage in, and which is not what the AD should have engaged in. Your arguments to us are credibility. Don't believe her because she led him on. She led him to the car, so everything was fine.
My argument is to the contrary. Believe her. Believe what she says. She says that she wouldn't have consented if she were not intoxicated. I believe her, i.e. she consented, but she claims intoxication. She says that she went along with everything that he wanted. I believe her. The court should believe her.
Wasn't that all in the early part of if you accept the notion that's presented to you by some of my colleagues, that consent at the outset doesn't give consent to everything that happens after, the part about her being ready to do whatever happened, all was much, much earlier in the evening.
No, I'm referring specifically to the moment in time where there's 3 chapters of the story. They're in the woods a first time. They leave the woods, she makes him buy condoms. They go back to the woods. That's where the alleged choking takes place.
Right.
They then leave the woods
And
and
they
go to her car, where she gets on top of him during sex and performs oral sex.
And then after that, she passes out.
Claims she passes out.
She claimed she passed out,
yeah.
but it was apparently believed by the review board.
Except that the review board didn't make a decision on that basis.
Counsel, what were you reading from originally that you said, I believe her? What's that document?
Oh, well, it's from her statements.
Original statement, not her testimony at the hearing, right?
Right. Let me give it to you, Your Honor.
But if she said that in an initial statement, and then she testified, and it's not entirely consistent with that, isn't that, again, for the trier of fact to determine which of those versions they're going to credit?
I mean, her testimony tracked her statement very,
She
very.
never said those things you read in her testimony.
But in her statement, she said, he kept saying it was a bad idea, but I kept telling him it would be fine.
How is that relevant to what happens after she withdraws consent? I mean, isn't this really of a piece with she initiated it, and it sounds to me the implication is therefore lost the right to withdraw consent? I think it's pretty clearly to the contrary.
No, but what I'm talking about, when I refer to, she wouldn't have done it if she were not intoxicated. That was actually a finding from the school. That was in the school's finding that she had said that. That she went along with everything he did was in
I'm
reference.
sorry, the school's finding where?
in-
What part of this proceeding is that finding?
It's initial findings after the hearing. And so, and then what you have from the appeals decision is kind of a strange change in tone, because right after the hearing, the school says we are not going to find a lack of, we're not going to base this on intoxication. And then the appeals decision, it really appears that it goes back on that and says that they are going to base this on, that the evidence, quote unquote, substantiated an inability to consent. That was the appeals board making that finding. And now the school's going back and saying, no, we're actually not going to base this on incapacitation. We're going to go back to what the school originally said. This is what arbitrariness looks like.
Let's talk about the choking you're quoting, because I think I found the language that Judge Garcia was asking you, where is it located? It's under non-consensual sexual intercourse and/or penetration. The complainant stated in the investigative report and in the hearing that she did not want the respondent to choke her during sexual intercourse, and that she would not have allowed that to happen if she were not intoxicated, correct?
Correct.
Okay, but she does and say she's trying to remove his hand. So let's go with what I perceive to be your argument, that she is agreeing to this part of this sexual encounter, the choking. But then she revokes it when she says that it was too much, that she's trying to pull his hands away and she can't.
Right, Your Honor, but
Why is that not? Let's
I'll tell you
accept
why.
what you're saying here.
I'll
Why
tell
is
you
that
why.
not revocation?
Because this discussion, I think, is premised on the idea that this is a case all about substantial evidence. But this case is also about, very much, the question of arbitrariness. And a school cannot come up with new reasons after its decision-making is over to substantiate the decision it made. And I used an example earlier about flipping a coin. If we had here evidence that said that they made this decision based upon the flip of a coin, I think we would all agree that that was arbitrary and would have to be vacated. And that would remain true, even if a few lawyers came by and said, well, the coin was right because there's other evidence that supported what the coin said. What we have here is the actual decision-making from the school, which never says that the reason why they found him responsible was because she tried to pry his hands off of her neck. And the appeals decision, which is the operative decision,
So your
never does
argument,
that.
Counselor, so your argument is that their initial determination, they said one thing, and then when it goes up on appeal, they change the basis of the determination?
The problem is that the hearing and this case
So
was
the determination one thing, and then the sustaining of the charges on appeal something different?
it is hard to keep track of for one reason.
Well, what are you claiming they did?
I'm telling you.
Succinctly.
I'm claiming that it was arbitrary because, on one hand, the appeals decision says that we're not disturbing the findings of the panel being the hearing panel. We're not disturbing the findings. Well, those findings were not based upon incapacitation. However, in the next breath, the appeals decision says that it is based upon the fact that the evidence substantiated an inability to consent, which is not what the panel found. And so what could be more arbitrary than you begin the case based upon incapacitation? The hearing is based upon incapacitation. The accuser says that she provided consent. She says, I wouldn't have been allowed to consent to getting a tattoo. I wouldn't have been allowed to consent to putting a down payment on a house. Why should I have been allowed to consent to sex? Admitting that she consented. The whole case is about consent, lack of capacity to consent, rather than whether she consented. Then, however, in the first step, the panel says we're not deciding it on that basis. And then in the appeals decision, it says actually we are kind of deciding it on that basis because we're going to say that this is all about inability to consent. And then after that's done, the school, in its arguments, as was identified earlier, is going back and saying, no, we're not going to base this on inability to consent. What is arbitrariness and capriciousness if not?
I'm a little confused. Maybe I've missed something in the review panel, but it does seem to me that under the findings, they do say on more than one occasion that there's no evidence of affirmative consent. And it is not in the same breath or sentence that they're referring to intoxication.
Are you referring to the appeal decision, Your Honor?
No.
Okay, so that's right, Your Honor. So the appeals decision is affirmatively saying we are not going to base this on intoxication, right? Even though that's what the
I
whole...
thought your argument was that the review panel never made a determination that there was a lack of affirmative consent, and I just don't read it that way.
No. If I said that, that's not what I meant. What I mean to say is this case, from the starting gun until the conclusion of the hearing, was not about whether she affirmatively consented. She admitted she consented. She said, I consented, but I shouldn't have been allowed to consent. But in the panel's decision, it then says, we are not going to base this on the intoxication question that formed the entire basis of the case. We are going to base this on an affirmative consent question, okay? Then the appeals decision appears to change and say...
You agree, I think was in response to Judge Canataro's questions, that the incapacitation based on intoxication can also be the inability to affirmatively consent. Not just I consented, but I was drunk, so no one should consider that consent, but actually physically unable to do so.
Yes, Your Honor, but in this case, we don't leave context at the door, right? The context of an inability to consent was only litigated on one question, and that was she incapacitated due to intoxication? And don't take it from me.
Well, that was my point before, that if you black out due to intoxication, that's sort of the same issue in question.
It is, except the panel affirmatively says we're not going to find that. We have a whole case. You've got, the educational hopes and dreams of my client built up in this, all about one question, which is, was the accuser too intoxicated to consent? It's everything about this case. That's why the videos mattered, and the text messages afterward about, her friend saying she didn't seem drunk, and my client was talking at the hearing about, oh, she doesn't look like she's stumbling, and their text messages are lucid. The whole
Counselor,
thing.
you're way over time, so if you want 10 seconds to wrap up, take them.
I appreciate the extra time that you all gave me today. The appellate division found what the record shows, which is that this case was about one thing, intoxication. It is arbitrary and capricious and not supported by substantial evidence to then decide this case based upon something else. We respectfully request that the appellate division's decision vacating the discipline be affirmed. Thank you.
Thank you.
So can I ask you this? The panel says that it finds that he's responsible for the charges, and I'm quoting here, regardless of whether the complainant was or was not incapacitated by alcohol. And the appeals committee says that there's evidence that substantiates her inability to give consent. So in response to your adversary's comments, how do you square those, and why does that not render the determination arbitrary and capricious, not for substantial evidence reasons, but because there's a shifting basis for the decision without explanation?
Thank you, Your Honor. There's not a shifting basis for the decision, and I just want to clarify what occurred here. So that decision by the Appeals Committee should be understood in terms of what his appeal to the committee said. And he made several arguments to the Appeals Committee, two of which are relevant here. His first argument was, she's not credible. Don't believe her testimony. And he concludes that by saying, and therefore you can't find substantial evidence based on this incredible testimony. And the second point he makes is that there is substantial evidence in the record of affirmative consent, and he recites largely the sort of same evidence he's pointed to about the beginning of the evening. So that portion of the Appeals Committee's determination is simply saying, we do find her credible. She's been consistent about her ability, but the Appeals Committee is not revisiting the basis for the review.
I'm just reading, though, from what they say. I think this is a quote, you'll correct me if I'm wrong, but I think that they say that she consistently maintained details surrounding the incident that substantiated her inability to give consent to the sexual activity. How is that not in tension with what the review panel says, which is that their determination is regardless of whether there was incapacitation by alcohol?
They're not, again, as I've explained, his letter to the Appeals Committee, the two arguments he made that are relevant here, there were some other procedural ones that I won't go into but are discussed in our brief, but his argument to the Appeals Committee was they did not make a finding of incapacitation. He says that in his letter to the Appeals Committee. He says that in his petition. He says that in his brief to the Second
I
Department.
would like to go to that point. It seems to me this argument isn't in the Article 78 petition at all. This argument about this bait and switch, or that the appeals panel did something different. As I read it, it says, he argued that the record before the school did not prove lack of affirmative consent by a preponderance of the evidence. Nevertheless, Stony Brook's appellate committee affirmed the findings.
Agreed.
I
Agreed that
don't
it's
see
it's
this
not.
argument anywhere.
I agree it's not preserved, but I do want to answer Judge Halligan's question. And I really think that the way to understand that sentence is in response to the particular arguments that he was raising in his letter to the Appeals Committee. The argument was, there were two arguments, again, that are relevant. One, she's not credible. Don't believe her testimony at all, and you certainly can't find substantial evidence based on it. And what the Appeals Committee is saying is, yes, she is credible. She has consistently maintained her story. They don't at any point indicate that they're departing in any way from the findings that were made by the review panel. And again, that's because they're just responding to this argument that he spent several pages on in his administrative appeal, saying she's not credible.
Can I ask you, who is the Appeals Committee? Are they judges? Are they lawyers? Who are they?
I believe they're faculty and staff.
They're faculty, so.
Yes. This is common in various agency proceedings where there's some kind of appeals committee or appeals board that consists of agency employees, and there's
Okay.
sort of a fact-finding body and then an administrative review body. Sometimes there's an express exhaustion requirement by statute, but this is just.
Okay.
So I just want to conclude by reminding the court that even if there was allegedly consent for some of the activity at the beginning of the evening, there were at least 3 times when she expressly revoked her consent, and the court should find that the university's determination was based on substantial evidence. Thank you.
Thank you.